Are you thinking of filing for divorce? If so, understand that one mistake can cost you thousands of dollars, undue delay in your case, and impact your financial future for years to come. If you're unlucky, it could even be all of the above. The truth is that the choices you make before filing will impact the outcome of your entire divorce case. Hi, my name is Miguel Jeffery. I'm a litigation attorney at Malone Hatley, and today we're going to talk about some of the most common mistakes that people make when filing for divorce, how you can avoid these financial and legal pitfalls, and what steps you can take to protect yourself and your future. Many people unknowingly make legal and financial mistakes before filing for divorce. Let's go over some of the most costly mistakes and how you can avoid making them. Mistake number 1, making sudden financial movements without the advice of legal counsel. Examples of this can include quitting a job out of nowhere, draining a joint bank account, or hiding assets. The reality is that courts are likely to view this as financial manipulation, and that can only hurt you if you're trying to settle your case outside of court, and especially in the courtroom. The best thing you can do here is consult with an experienced divorce attorney, tell them the facts of your case, and make sure that they give you their insights as to what you should do financially before you do anything. The second mistake that can be very costly is assuming that assets are going to be divided 50-50. There's an adage that says a little bit of knowledge is a dangerous thing. That is definitely true here. A lot of people know that there's at-fault grounds and that there's also a divorce that is not at fault. But just because your divorce is not at fault, and just because the other side is agreeing to go through the divorce process, doesn't mean assets are automatically split 50-50. There are many factors that a court has to consider to include a factor that says any other factor the court thinks is important. And there's a lot of financial and non-financial contributions that the court also has to assess. So in sum, it is far from straightforward, and it can get pretty complicated. The best thing you can do is consult with an attorney that has experience with divorce actions and get their guidance before you file for divorce. And the third costly mistake that many people make is they avoid tax implications. They think taxes are complicated. They don't really factor them in their divorce action. But there's several things that can impact your tax liability. For example, taking early withdrawals from retirement, failing to consider how spousal support plays into taxes, and failing to consider how property division impacts your taxes. Failing to consider these things can be detrimental to your financial health for years to come. So it's best to consult with a financial expert and or an experienced divorce attorney to ensure that your tax liability is as low as it can possibly be. Divorce is a financial and legal process that requires careful planning. These are key steps that you should take to protect your interests. First, gather and organize all your financial documents. The reason you need to do this is because courts are not going to want to proceed if they're not sure what the party's finances are. For example, tax documents are often the best way to show what your finances are. If the judge doesn't have that and the judge is trying to make a determination as to support, for example, that judge may continue the hearing and hold you accountable for attorney's fees for the delay. So the best thing you can do is anything that you think might be important in your divorce case, go ahead and gather it and organize it so you can provide at a moment's notice. These documents include bank statements, any loan applications you submitted in the last 3 years, and especially your tax documents. A second step you can take to protect yourself is understanding the assets and liabilities of your marital estate. Most times, clients aren't fully aware of what is marital property, what is partial marital property or hybrid property as it's called, and what is separate property. The best way to understand all of this is to speak with an experienced divorce attorney and let them give you their analysis on what the property classifies as. An example that I can speak of on my own caseload is there was a client that thought that the home belonged to him as separate property because he made the down payment, he paid the mortgage, and he improved the home. According to him, the wife didn't do anything whatsoever. This client was surprised to learn that this was actually considered at least partial marital property because it was bought for the purposes of the marriage. So the consequences can be drastic if you don't understand the classification of property. A third step you can take to protect yourself is to be financially independent. If you know a divorce action is pending, or you think one might be pending, it might be best to put your income into your own bank account as opposed to the joint bank account, where then the other party can take it and you're trying to fight to get it back. It also makes it difficult for the judge later on to determine what part of the bank account belongs to who. Now, as stated before, you do want to consult with an experienced professional before you make any financial movements, but it is good to be financially independent as much as you are able. And the last step that you can take to avoid a costly mistake on your case is don't make a decision based off of emotion. If you make an emotional decision because either you hate your spouse or you're just angry in that moment, you send that one email you shouldn't, it can haunt you for years to come. Instead, be strategic and be practical. And the best way to ensure this is to have a qualified divorce attorney with you that is guiding you through the process, that is giving you their professional insights on what to do. Legal missteps can have serious consequences on your divorce case. Here's some of the most serious mistakes that you can avoid. The first one, moving out of the marital home too soon. The reason you don't want to do this is because, let's say children are involved. The court might think that you've willingly given primary custody to the other party through your actions. It certainly waters down any argument you have as to why your spouse is unfit to care for the children like you are. But further, there's even a at-fault ground in Virginia called abandonment of the marital home. If the judge feels you didn't leave for good reason, you might be found to be at fault, and that can greatly impact the distribution of assets. Now, there are times it might be appropriate for you to leave the home, such as if you're being physically abused, but nonetheless, it's best to consult with an experienced divorce attorney, tell them the facts of your case, and get proper guidance. A second critical mistake to avoid is posting about your case on social media. You'd be surprised how many cases have been won or lost because of a post that came in from Facebook or Instagram. Posting about your case on social media can never help you. It can only hurt you. Now, the best practice here would be simply don't have social media or don't use it during your divorce case. But if you find, like many of us, that you have to use Facebook, you have to use Instagram, at a minimum, don't talk about your case on there. If you post pictures of the children, make it just about you and the children and having a good time. And even then, be careful, because if there's alcohol in the picture, the other party can say you're under the influence while caring for the children. So best practice is just don't do it. But if you have to, be careful and don't talk about your case. And the last critical mistake to avoid is violating a court order. Now, it probably sounds like common sense to a lot of folks. You'd be surprised how many times people violate a court order and then it comes back to haunt them. And that could be orders in terms of child support, custody visitation, and especially protective orders. If you violate a support order or a visitation order, you can be found in contempt of court to a show cause, and that can range anywhere from simply being reprimanded by the judge to even being jailed for a certain amount of days. And violating a protective order is even more serious. That leads to a Class 1 misdemeanor, violation of a protective order, which can carry up to 1 year of misdemeanor time. So the best practice there is abide by court orders as best as you're able. And if you're really not sure about a court order, what it's saying, or your ability to comply, definitely consult an experienced divorce attorney as soon as you can to avoid serious legal consequences. Now, even misconceptions about a divorce action can lead to costly mistakes. We're going to debunk some of the biggest myths out there. The first one is that in a divorce action, the wife's going to give everything, or the court's just going to automatically side with her. It's actually not true. The way that the law is written, it's gender neutral. There is no preference for wife getting anything. In fact, there used to be a time in custody visitation that there was something known as the tender years doctrine, where mother presumably was going to be the primary custodian. That's not even the case anymore. The court's going to assess the merits of both parties, their strengths, their weaknesses, but by no means is a woman in a divorce proceeding or custody proceeding automatically going to win just because of that. The second myth that is often encountered is people think that if there's adultery committed, that's it. They're automatically going to give everything. But that's not necessarily true. In some states, adultery isn't even a basis for an at-fault divorce. In Virginia, it is a basis for an at-fault divorce. But even then, it's up to the judge how little or how much weight he or she wants to give the adultery. If everything is otherwise great for you as a client, and you've been exemplary husband or wife, and the other side committed adultery, and you can prove that to the court, yes, you might win a lot. You might get a windfall. But if there's other facts out there, such as you contributed to the downfall of the marriage, maybe the court thinks that you financially manipulated your partner, things of that nature, it's far from certain that it's going to guarantee an outcome that's good for you. It could just be one of many factors that the court factors in. So as usual, it's best to consult with an experienced divorce attorney and see what that attorney's analysis is. The last myth that exists, and perhaps the most dangerous one, is our divorce action is amicable. We don't really need attorneys for this. From my personal experience and being a divorce attorney, I can tell you that is very far from the truth. I had a case, notably, where it started off just like that. Husband and wife are going to divorce, no attorneys, it's amicable, they both agree it was for the best. They drafted their own separation agreement, no lawyers involved. I don't recommend that. At issue was the husband's military retirement. He had told the wife, I'm not going to tell you who I represented in this action, but he had told the wife that they were going to address the military retirement at a later time, that it was too complicated to put in this agreement. She went ahead and did as he said, she signed the agreement, and years later, she asked for her share of the military retirement. Now you probably know where this is going. Husband said, well, that's not true. We never addressed that in the agreement. In fact, the agreement said anything that's not addressed is considered final. But then wife came back with, well, actually, I have these emails showing that you meant to give me the military retirement. And because it wasn't drafted by an attorney, there was no clause keeping out evidence outside of the document itself. And it became a hotly contested issue. So that's probably the best example I can give you of how just because it's amicable, it doesn't mean that it can't go south. So it is best to retain the services of an attorney. Divorce is one of the biggest legal and financial decisions, if not the biggest decision of your life that you're ever going to make. And by avoiding common mistakes, and especially making the right moves, it can go a long ways in protecting your rights, your assets, and your future. If you're thinking of filing for divorce, avoid making costly mistakes. Contact Malone Hatley, your partners in divorce and estate planning today, and get expert legal guidance to help you through this process.